Hi everyone, my name is Beth Brown and I am counsel in the Pensions Group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. Running with the Pension Scheme Act theme for a third month, in this episode I will talk about the Pensions Regulator's draft policy on its approach to the investigation and prosecution of the avoidance of Section 75 debt and conduct risking accrued scheme benefits criminal offences. The draft policy was published for consultation on the 11th of March, and the consultation closed on the 22nd of April. Today, I'm going to summarise the key points of the draft policy. The first important point to note is that the regulator has made it clear that these new criminal offences are not intended to change the corporate behaviour in the UK, but rather are to be used to address serious intention or reckless conduct that was already within the scope of its contribution notice powers. The regulator wants to use these powers to deter repetition of similar bad behaviour and act as a warning to others where the seriousness of the behaviour warrants such intervention to further their statutory objectives and protect savers. For example, where the primary purpose of an act is abandonment of the scheme without appropriate mitigation, or the scheme has been treated unfairly. The regulator has made it clear in the draft policy that if a person has been convicted of or is subject to an ongoing criminal proceedings regarding an act or failure to act, the regulator will not use its civil penalty powers to fine that person. The flip side to this, though, is that where the regulator will not pursue a contribution notice because, for example, the target's resources mean that the amount of recovery would be very low, it would still consider prosecution as a deterrent effect if it's in the public interest to do so. It's worth noting that there is no limitation period applicable to the criminal powers. The final general point I would make is that although in England and Wales, prosecution of these new offences can be instituted by the regulator or the Secretary of State or by or with the consent of the Director of Public Prosecutions, ultimately, the power to find a person guilty lies with the courts. So let's now look at some of the detail. The draft policy covers two of the new criminal offences, being the new criminal offence of the avoidance of a statutory Section 75 employer debt, which applies if any person acts or fails to act with the intention of preventing the recovery of the whole or part of Section 75 debt, prevents such a debt becoming due, or reduces or compromises that debt. And the conduct risking accrued scheme benefits criminal offence, which applies where a person acts in a way which detrimentally affects, in a material way, the likelihood of accrued scheme benefits being received, provided the person knew, or ought to have known, that the act would have that effect. The regulator has given some helpful guidance in respect of this offence. Firstly, it's said that when deciding if the material detriment test is met, it will take the same approach that it already takes when considering issuing a material detriment contribution notice. The regulator would not expect to prosecute anybody who could establish a statutory defence to a material detriment contribution notice. Secondly, when it comes to considering whether a person knew or ought to have known that their actions would cause material detriment, the regulator will consider the circumstances as they were at the time of the act, and they will not be using 2020 hindsight, i.e. they will not be basing the decision on knowledge of subsequent events. Moving on to the application of both the criminal offences, which can apply to any person, the regulator has confirmed that these criminal offences can apply to the principal offender and any person who helps or encourages somebody to commit one of the offences. However, it's clear that a person will be presumed to have reasonable excuse unless this is disproved. When considering the reasonable excuse defence, the regulator expects there to be sufficient evidence such as contemporaneous minutes, correspondence, or written advice. Having said that, the regulator may consider documentation from before the date of the relevant act or omission if it's relevant. So, for example, if it indicates a person's intentions. While the existence of a reasonable excuse will be fact-specific, there are 3 factors that the regulator will consider. 1. Whether the detrimental impact was an incidental consequence of the act or omission. So an example of an incidental detrimental impact is where the employer's business is affected by protests organised by a pressure group opposed to the employer's activities. By contrast, an example of detrimental impact, which is not incidental, could be where a key supplier terminates a supply contract with the employer with the aim of forcing that employer into insolvency so they can then buy the employer's business out of insolvency without the scheme. 2. The adequacy of any mitigation provided to offset the detrimental impact. For example, if an employer is sold and part of the sale proceeds are paid to the scheme, and alternative financial support is put in place for the scheme, such as a guarantee from the new employer, it's likely that the regulator will consider the detrimental impact to have been mitigated. 3. Where no or inadequate mitigation was provided, whether there was a viable alternative which would have avoided or reduced the detrimental impact. What this means is that if there is a viable alternative with a less detrimental impact, it is unlikely that there would be a successful reasonable excuse defence. When considering this factor, the regulator will be aware of the commercial situation. For example, if an employer raises debt with a yield higher than a conventional bank debt, but this debt is critical for its survival, there is no less onerous source of finance available, and overall it's better for the scheme if the employer survives, then it's possible that the reasonable excuse defence will be considered to be met. The regulator has also said that when considering using the new criminal powers, it may give some weight to the communication and consultation with the trustees before any action took place, notification to the regulator, and where it is involved, the openness and timeliness of communication with the regulator. Having said that, the formal clearance statement is not an option in respect of these criminal offences. Given the wide application of these 2 new criminal offences and the criminal element of them, I think this draft policy from the regulator, while for some may not go far enough, for most will provide helpful clarity and guidance. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.